We're going to look at now some further skills, and the skill is reading the facts of a reported case. Now, previously, or up to now, I've looked at the exercises around the verbal evidence that witnesses might give to you, to listen, to understand, to be able to ask questions, to know what's relevant, to know what's not relevant. A whole lot there. Okay. But now I've also said that you will get facts from a reported case. So that's what we're going to deal with now. A reported case. So what I'd like you to do right now is download the case that's available for you that I'll be using in this discussion. It is the case Transport and General Workers Union, another versus Bayete Security Holdings. So we're going to use that. Now, before we get into actually reading it and so on, I have to explain some things to you that that are key to being able to read a reported case. Okay. So the first thing we need to understand is that there are parties involved. There are people. Now, there can be individuals. In this case, it's a union, Transport and General Workers Union, and another, so that sometimes there can be two parties, okay? And then Bayete Security. Now, so they're parties. Let's just get into that. The first is called an applicant. So when I talk about the applicant, I'm talking about the first party, in the title. That's the applicant, but also to understand that's the party that actually refers the matter to the court. They're the one who's taking the matter on to court. Now, there can be more than one applicants. So in this case, Transport and General Workers Union, and another tells you that there's more than one applicant party that is taking the case to court. The other thing to understand, other parties referred to as as the respondent. That's the party that is responding to the case brought by the applicant. Again, there can be more than one. In this case, the respondent is Bayete Security Holdings. The legal forum is something we need to pick up. So if you have a look at that, the case that I'm referring you to, you'll see the legal forum is the Labour Court. It's in Johannesburg. It's in December 1998. Okay. Then in your notes, the judge or arbitrator. Now you need to know this because I found the students get very confused about this. A judge is referred to, as I put in the workbook for you, Maloney J. J for judge, not John. Okay, not James or anything. It's judge. Or Maloney AJ, acting judge. Maloney JP, judge president. Maloney JA, judge of appeal. Maloney C for commissioner. So why that's important is because there's this hierarchy of judges. As there's a hierarchy of courts, Labour Court, Labour Appeal Court, Supreme Court of Appeal, and Constitutional Court, there's a hierarchy of judges. So some judges will be Labour Court judges. That's on the lowest rang of Labour courts. Okay, so that's referred to as J, Maloney J. So you need to know that. A for arbitrator, C is for commissioner, that kind of thing. All right. So what else? The other thing you need to note is the place and time. So have a look at the judgment. It says 9th of December 1998. It's in Johannesburg, and that gives you some further information that you need to be aware of, and I'll talk to that a little bit later. Now the more difficult part is to look at what is the applicant's case or version. Now at this stage I want you to stop the video. I want you to read this judgment right from the beginning there, paragraph 1, all the way through to the end. Oh, the other thing I need to just note is the judgment is Grogan AJ. AJ is acting judge. Okay, so stop the video here, and then we're going to look at the question of what is the applicant's case or version. Right, I've assumed that you have done what I've asked. You've had a look at that. So when we look at this actual judgment, we're going to see that there's the applicant's case, and then we need to also look at what is the respondent's version. So before we get into that, I'm going to unpack some of the things in the version that you've got. You'll see there are certain words, etc., that have been highlighted and that kind of that I've done to help you, because we're going to go through some of these. So these are the legal terms that one needs to be aware of. And in your workbook, I've also put some of these terms for you to understand. The first is statement of claim. In paragraph 1, it's in bold there, statement of claim. The respondent failed to respond to the statement of claim. What is the statement of claim? It's the legal documents that the applicant files with the court. That's what we call those documents. It could be one page, could be many pages, and we call that a statement of claim. Then there's the unopposed role, because it says in paragraph 1, it was set down on the unopposed role. To explain what that means is that the courts have two roles, or like literally, roles of cases that come before it. And what happens is, if the applicant files a statement of claim, but the respondent does not, then it means that the applicant's case is unopposed. This is before it gets to judgment and all of that. It's the process that follows. It's unopposed. So it gets put in one box, okay, or one pile, put it that way. And then obviously if it's opposed, then it's in the opposed role. The opposed role will mean that both parties are there. They're going to fight the case on a date to be advised, and they'll both be in court. And unopposed means only one party. The other thing about that is proceeded by default. The matter proceeded by default. Default means the case proceeded in the absence of the other party. So in this case, Bayete Security, the respondent failed to respond, failed to lodge its own cases or documents, and therefore it's what we call proceeded by default. Now it happens often, or fairly often, where a party, for example, if an employee fails to rock up for a disciplinary hearing, that would be regarded as default. If the employer fails to rock up in an arbitration, the arbitration is held by default. So just get used to these terms and you'll find it a lot easier to understand what's going on. Then it says the applicant filed an affidavit which he deposed. What does that mean? It just means that he read, first of all, an affidavit. Affidavit is a written document which is made under oath. In other words, you swear to tell the truth, the whole truth, blah, 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 when it's written down, and it's signed before a commission of oaths, so that it becomes a very important piece of evidence, because it is a sworn affidavit made under oath. And then deposed just is a fancy word for saying written. Okay. Okay, so that's deal with that. The onus. Now I see I haven't put this part into your workbook, but bear with me. Where is the word onus? Onus is in paragraph 4, where it's in bold on the very left-hand side. It says onus. Does the onus shift to the respondent? Okay, to prove. So onus is a term that is referred to as the duty to prove. Who must prove what? That's what we call an onus. So in court, the applicant has to prove, doesn't just bring the papers and file a statement of claim, but actually bears the onus, the duty to prove that case. So that's what onus means. And I'm sorry it's not in your workbook, but anyway. An averment, also in paragraph 4, an averment that there's been discrimination. An averment is just a claim. It's a fancy legal word for claim. 1956 Act, that's in paragraph, where is it? Paragraph 7, it's in bold. 1956 Act. So what that is referring to is that there was a previous Labour Relations Act, same word, same title, but in 1956, that legislation has been not overturned, but set aside, because there's new legislation, 1995. So the current Act, Labour Relations Act, is 1995. So you just need to know that there was this previous Labour Relations Act, which was referred to by the judge there. And then claims made in the alternative. Where did I put that? Okay. Okay, that's not stated. Claims made in alternative not stated directly in the case, but I want to refer you to paragraph 3, where it says the applicant referred a dispute to the CCMA. The document certifying the dispute was not resolved designated the dispute as alleged unfair demotion based on alleged discrimination. So what is happening here, and I've put in your notes there, is that in law what happens sometimes, you have like lodge a case around one thing, in this case unfair discrimination. You say I've been unfairly discriminated against, but then you say, well, if the court doesn't find that that is the case, then I'm also alleging demotion. Okay, so it's like an alternative way of bringing a case. Okay, that's just a bit of legalese that you need to understand. Okay, so now please go and read that case now that I've explained that to you, and then we're going to unpack it in terms of exercise. You see, answer these questions thereafter. Right. So you've read the case. We're going to go through in your workbook, who is the applicant? Well, the applicant, the first party, is Transport and General Workers Union and another. Who's the respondent? Bayete Security Holdings. Who's the presiding officer? Grogan AJ. He's an acting judge. Where did the case take place? Labour Court, Johannesburg, December 1998. What was the applicant claiming? Now we get to a little bit more difficult. All right. So you've read the case. Now I'm going to sort of direct you to what he's claiming, and we're directing you there to paragraph 3. I'm going to read it for you. Paragraph 3, the applicant referred a dispute to the CCMA. The document certifying the dispute was not resolved designated the dispute as an unfair demotion based on alleged discrimination. So that's what he's claiming. Okay, when you claim, you're putting forward your dispute. You're saying, this is what I'm disputing. I'm claiming, I'm alleging that I was unfairly demoted or alternatively unfairly discriminated against. So that's what he's claiming. That's the basic substance of what he is claiming. Okay, and then the question is, what facts? So now we're moving into, well, I've done now the issue and dispute. Remember I said that I don't always fall one after the other. So now we're going into the question of what facts, and where do we find the applicant's case? Well, let's read paragraph 2. If you've read paragraph 2, it says, the applicant filed an affidavit in which he deposed to the following facts. Now, quite often what happens is judges and so on don't always have a heading that says the facts of the case, but will usually say something like, these are the facts. And so you pick up, that's what we're looking at. He deposed, where we've discussed that, to the following facts. And that's in paragraph 2 is where those facts are set out. What I'm trying to get you to do is see not just the judgment as such, but to see the logic that comes in the way this is put together. And then what is the respondent's defense? Well, okay, if you've read it, you might find this a little confusing, and it's not surprising because it's a trick question. Paragraph 1, all right? Let's have a look at paragraph 1. It says the matter, and I talked about the statement of claim set down in the unopposed role, though the matter proceeded by default. Okay, so in other words, He wasn't there. Sorry, not he. The Bayeta Security wasn't there. So what do you say? Well, what is their case? We don't know, because they weren't there. So be aware of that. That happens in that way, and I already explained that. Right. So that's the sort of real outline of what we're talking about here. So what I want you to do, is I want you, again, read the case. It's not a long document. And yes, I want you to read it from beginning to end. Pause the video, read it again, because now what we're going to do is we're going to apply a look at FELAC. I've already shown you the facts, where the facts are, but I'm going to unpack it so that you can see the logic and the way that the law works. How do you solve a problem in a legal way? And this is an example of that. So please read it again, and then when you've done that, let's look at the video again. Okay, so the facts. They're in paragraph 1 and 2. Paragraph 1 is kind of like the introduction about being unopposed and that kind of thing. Paragraph 2 is the applicant. We don't know the name. Hey, we don't know in this, up to now we don't know, because it says the applicant. But let's read it further on. The applicant filed an affidavit in which he deposed to the following facts. He was employed by the respondent as a security guard in December 1994. At the end of 1996, he was offered a marketing job together with 2 former shop stewards. From the time of their appointment, the applicant and his colleagues were paid salaries of 1,500 a month plus commission. About a month later, the respondent employed one Vaynant Lowe at a salary of 4,500 per month. Lowe was introduced to the applicant and his colleagues as a, quote, well-experienced person for the job who will teach us to perform. Thereafter, the applicant claims that he observed Lowe had no experience in the security industry. He then queried the disparity between his remuneration and that of Lowe. Thereafter, the applicant's sales position was abolished and he was demoted to his former position as a security guard. Right, so that's his story. What have we got? Facts. All written out for us. Now you can picture that where does the judge get this? The judge doesn't just like make it up. He gets this from the statement of claim, the written version, the affidavit that the applicant has filed. Then I've already explained to you as well, where's the issue in dispute? And you see that this is what's in dispute. The dispute is about the applicant saying that he's been unfairly demoted and alternatively was unfairly discriminated against. That's what he's saying in terms of his affidavit, and the court sets out for us now in a FELAC fashion, in facts, and now the issue and dispute. Now, not always in that way, but generally, very often like that. Now, we need to look at the law. The law is in paragraph 4. And it says this: the only form of unfair labor practice that can be adjudicated by this court is unfair discrimination on the grounds specified in item 2.1 of Schedule 3. That's a reference to the Labour Relations Act as it was at the time, and I'll explain that in a little bit more detail. The applicant is accordingly obliged to demonstrate, this is the law, okay? The applicant is obliged to demonstrate that his claim, what's his claim? Unfair discrimination, alternatively demotion, falls within the terms of that provision. In other words, when you're claiming something, you've got to find the issue and dispute. Your claim has got to be in some law or other. It's not just a question of making it up. You've got to actually say, okay, well, the law says you can't unfairly discriminate and you can't unfairly demote, so that you're referring to that law. Now, in this case, it was in Schedule 7 of the Labour Relations Act at the time. I'll explain that a little bit now, but let's understand this. The applicant is accordingly obliged to demonstrate that his claim falls within that provision. The applicant is obliged. So, well, that's about the onus, isn't it? The applicant must prove that his claim, that is discrimination or a demotion, falls under the Labour Relations Act. To do so, he must prove, and this is the law, that he's been the victim of discrimination. And he quotes a case there. You see that that's a case, Public Service Association and others versus Minister of Justice and others. So the judge is saying the law, and the law comes from where? The Labour Relations Act? No. It comes from this case, public servant's case, has said that an applicant must prove there's been the victim of discrimination. Now you're learning a lot of law here. Maybe you're not realizing it, but you're learning that you can't just claim unfair discrimination. You have to prove, without proving, first of all, logically, do you see this? Logically that you were what? Unfair, you were discriminated against. Prove that first. The court says in the first instance, prove that he's been the victim of discrimination. Logically, you have to show that you were discriminated against before you can show that it was unfair. It is illogical to say it was unfair first and then discrimination. It is discrimination first. Why? Because the case law says that. Then it says only once this is proved does the onus, duty to prove, shift to the respondent to prove the discrimination did not amount to unfair discrimination in the sense contemplated by item, and that's the reference to the law at the time. And averment that there's been discrimination is not sufficient to shift the onus in this sense. And then quotes another case. So what is the judge doing? The judge is saying, I'm not just making this up. This is what other judges have said in other cases before this one. Okay, so that's the law. So yes, we're going into a lot of detail there, but step back and say, right, what we've got the facts, we've got the issue, we've got the law. Now, the application in paragraph 5 to 8. So, having set out the law, the judge then says, in my view, the applicant has not succeeded in surmounting the first hurdle. The only facts from which he expects the court to infer that he was discriminated against was that he, a black, was earning 1.5 and that Lowe, a white, was earning 4.5. Okay, now, one of the reasons why I'm using this case, there's a number of reasons, is because in my experience, many people, you're sitting around, you're having a beer, and people will say, yes, it's just so unfair. I'm being paid this, and that other oak over there, or that other lady, or whatever, she's been paid so much more. It's clearly unfair. And you'll see that is not sufficient. The court is saying, and I'm teaching you law here, maybe you're not realizing it, but I'm teaching you law to say it's not discrimination to say one person earns this, another person earns that, and the one is more than the other. It is not discrimination. Now, I know because this case is old, it's 1998, we're talking about little amounts, 1.5 and 4,000. So right now, the figures will be a lot more. The amount doesn't matter. The question is that you're saying because I earn a whole lot less than that person, it must be discrimination. And what the court is saying is that not the case. The applicant admitted in evidence he did not know what work Lowe performed, what his educational qualifications or experience were, for whom Lowe previously worked, and for how long. The applicant also conceded that Lowe was designated a manager and he was not. And in paragraph 6, the applicant also claimed that in his view, Lowe had no experience in the security industry, but no evidence was led in support of this claim. So you're learning law here, simply making a statement that's saying, this guy's got no experience. Well, okay, that's your view, your version, so now prove it. Where's the evidence? Even if Lowe did lack experience, it does not follow that by appointing him, the respondent discriminates against the applicant or other employees, however experienced they may have been. Now, this is also the key law. I'm saying you're going to learn law. It is so that to pay one employee more than another for doing the same work may have amounted to an unfair labour practice under the 1956 Act, where, quoting a judgment, SA Chemical Workers Union. And would also be so under the new Act, the 1956 Act, if done for an arbitrary reason. However, the mere fact that an employee pays one employee more than another does not amount to itself discrimination. And then there's Dutoy et al. Now, what is that? That's a textbook, okay? Dutoy et al. The name of the textbook is Labour Relations Act. Discrimination, says the judge, takes place when two similarly circumstanced individuals are treated differently. That is discrimination. But pay differentials are justified by the fact that employees have different levels of responsibility, expertise, experience, skills, and the like. And then, so what is the judge doing here? He's doing the A. He's applying, taking the law and saying, yes, but in this particular case, he hasn't proved that he was discriminated against. Because in paragraph 8, the applicant has failed to place before this court any facts that justify the conclusion he was paid less than Lowe merely because he is black and Lowe white, or that the difference in their incomes was for any other arbitrary reason. There is accordingly no basis from which to draw the inference that the applicant was discriminated against in the sense contemplated, and then it's referring to the law. Okay, so I know I'm going into a lot of detail about the law, what it says, and I'm reading this for a purpose. Because not only am I teaching you some law, but stepping back, I want you to see the logic. And the logic and the conclusion now is in paragraph 10, application is dismissed. The logic is the court doesn't start the case and say application dismissed. It's not legal thinking to work like that. You always follow, as this is an example, the facts, the law, the issue in dispute, the law, and then your conclusion like that. Okay. So that's one exercise, and we're going to use this judgment on a few occasions in the future as well. But let's just summarize this. What have we learned so far in this module? Well, I've shown you that there are legal terms that you just have to get used to and understand. And obviously, the more you do it, the easier it becomes to understand. And most of them are not figure like applicant, respondent, that kind of thing. You need to read a case. That's why I've said to you, read this case a few times so that you get to understand it. We've learned a whole lot about the practice of law, that parties can choose sometimes not to defend a case. If a party is not present and the case proceeds anyway, you have to refer a dispute, you have to write an affidavit. You can't just knock on the door and say, oh, here I am, blah, that kind of thing. It doesn't work like that. Or write a letter. There's a process that you have to follow that I've briefly explained here. That there's old legislation, 1956 in case Act, and there's new legislation. So what that means is you have to make sure that you have the current legislation. Don't look at an old legislation. Make sure you've got the current one. A little bit difficult now because it was both called Labour Relations Act, but understand there's new legislation, or new now, relatively old already, isn't it? And then you can't just say things. You can't just say, oh, well, this is unfairly discrimination. You have to prove your case. You need your evidence. Okay, so we've learned actually a whole lot about law, in this case, unfair discrimination. But I'm not like, the point is not to teach you unfair discrimination. The point is to teach you, and you start to see how this all fits together, to understand how FELAC works in the context of case law. And because case law is so important, you need to make sure that you have understood what we've covered in this particular module.